Thank you very much for inviting me. This is actually, I took work in progress seriously, so this is a very much a thinking project, which I intend to think about more after hearing your comments. Some explanation about the genesis. For 12 years now, I have been ABD for a PhD in political theory and IR theory, and I've decided now that I have tenure and things are comfortable that I should actually try to finish it. And so this is sort of my first stab at it. And a particular idea in political theory really grabbed me. One of my advisors, Richard Tuck, wrote a paper where he talks about Thomas Hobbes. And the basic idea is, where did Thomas Hobbes come up with the state of nature, which is a true innovation in political theory? He didn't get it from the Bible. He didn't get it from the Greeks. He didn't get it from the schoolmen. And Tuck made the rather simple but I thought innovative suggestion. Well, he got it from empirical observations about international behavior, both within his own world and within the world of Thucydides and the Peloponnesian states and the Peloponnesian War. And so that really stuck with me, the idea that the international context in terms and of course the state of nature idea is really the mother lode of modern political theory, because that inspired liberalism and the communitarian response, and today modern political theory is still pretty much trapped in that mode of discussion. The second genesis was in what I call my Article 3 and International Law Trilogy, a series of articles that I wrote about different aspects of Article 3. I discovered something, which is that the courts really, if you look at Article 3 on its terms, and if you look at the 1789 Judiciary Act, the primary function of the courts was conflict avoidance, both interstate and international. They were intended to be foreign policy institutions, and the paradigmatic example of that is the original jurisdiction clause. If you think about the fact that the federal courts, what's the one aspect of the federal courts, the judicial power, that Congress cannot touch? It's the original jurisdiction, uncontroversially. You can have arguments about that. And the two categories there are states as parties, where it's state A versus state B, or state versus foreign state, or cases affecting ambassadors and so forth. So one thing that came clear to me was the extent to which Article 3 addressed the courts as foreign policy institutions that were to mediate conflicts. And the specific example of that was the Alien Tort Statute. Now, the Alien Tort Statute is a part of the 1789 Act. It's not in the Constitution, but as a lot of you know, it's a very special statute because it was enacted by the first Congress, and it deployed Article 3 in various aspects. And the Supreme Court recently decided a case that's called Souza, where they said that the Alien Tort Statute was available for international human rights litigation, even if it's a non-U.S. citizen involving claims that have no relation to the United States. And I wrote an article where I thought that a very dispositive original public meaning said that it's just inconceivable to think that they would have thought of this particular function, and that in fact it was a way to allow aliens who had claims with regards to injuries to their property or persons within the United States or in areas where the United States had influence to bring claims in federal courts. And so those are the genesis of, and so after doing that kind of work, I decided to step back and try to theorize a bigger picture and make sense of this. And this is sort of what I came up with. So definition, what do I mean by the Foreign Affairs Constitution? It's the Constitution as it regulates interactions between the United States or the citizens thereof and foreign states, citizens or subjects. And I don't want to get into too many debates about what original public meaning or original intent. All I'm trying to say is that this is an important part of the Constitution. And if you think about this part of the Constitution, originalism, however you define it, doesn't make as much sense as you think it would, for the basic reason that the design of it necessarily reflected a new revolutionary militarily weak state, right? Now, and that if you look at it, the United States today is in a particular geopolitical context where war was a feature of life and reciprocity was the governing principle, and the United States was in a position where it had to win acceptance into the community, so treaties were particularly important, and there seems to be a misfit between that particular type of blueprint and what the United States is now in the geopolitical context. So what does a militarily weak state's foreign affairs constitution look like? It seems to me that it would make it hard for the state to go into war unless it was a defensive war, but easy for the state to get out of war. Treaties would be incredibly important because a treaty reinforces the country's identity as an actor in the international community, and the most important treaties are peace treaties, right? Courts are very important in foreign policy as conflict avoidance mechanisms, right? So if you want to disable a conflict and have a diplomatic resolution, you want to use the courts and deploy them in a sense to provide an alternative peaceful resolution of disputes. There was something called the denial of justice claim, which was something that existed in international law, and the basic idea was if somebody was denied justice in a particular nation's courts, the offended subject sovereign could wage war on you. And so the U.S. was particularly concerned about denial of justice claims, and one way to get around that was to provide national forums as opposed to biased state courts and juries. Another way is to incorporate whatever the customary international standards were into your own substantive standards of due process, so you couldn't be accused of falling below a civilizational threshold. So if you believe this, then there's no problem with international law coming into U.S. substantive standards, right? And in fact, these are sort of hypotheses based on the vision of the militarily weak state. And this is more controversial, but I think that in times of emergency where you actually are in a state of war, I think a militarily weak state will necessarily have provisions in its constitution, and this is something that Jack Balkin has written about, that will enable the domestic authorities to exercise emergency powers. And it's telling in this light to see that in the Third Amendment, for example, the quartering provision, you can't quarter troops in peacetime, but then it says in times of war you can under regulation. The writ of habeas corpus may be suspended, and so if you take this view, once you've crossed this threshold, obviously there's difficult threshold determinations. Something like Lincoln's action of suspending habeas in the rebellion would be not so objectionable. So there's this interesting series of doctrinal prescriptions you can generate. So one question, I think Jack will probably talk about this, is the extent to which this characterization of the United States at the classic framing moment from 1787 to 1789 and later on to 1791 fits this conception of a militarily weak state. Because clearly there were people in the country who desired the United States to be a great power. I like to Jack sort of is one of the leaders of the expositors of the Madisonian strain among the framers. There was the Hamiltonian military-industrial complex strain. I like to, when I teach this stuff, I like to liken them to different characters in the movie Top Gun. Yeah, and Hamilton is the Tom Cruise character, and Madison is the Iceman character, and George Washington is the Viper character. The guy who's missing is sort of the John Jay foreign policy character, who has is an antecedent for a particular type of statesman. Thinking of Dean Acheson, Leo Root, Charles Evans Hughes, who sort of were attuned to foreign policy issues and sort of highlighted them as the most important ones for the nature of, or for the constitutional blueprint. And so I think that in this time period between 1787 and 1793, up to the Jay Treaty, really, there was this pretty strong felt perception of security threat. So I've sort of outlined what a militarily weak state's constitution would look like, come up with a theory, and then the big question is: so do we need to? Can we stick with it now under radically different circumstances? And the way I answer that is, I've been accused of being an originalist, and I think at some level I'm this. If Jack Rakoff is an originalist, I'm an originalist too. I don't know if that's going to satisfy Jim Fleming, but I think it still makes sense to go with it. But you just have to have a different kind of argument. And the three that I suggest are sort of a Rawlsian veil of ignorance argument. If there's one truth in international relations theory, it's that no country stays top dog forever. And under these circumstances, perhaps you want to have a moderating position on these things. Second type of argument is ironically, a militarily weak state and a hegemon both want the status quo, right? And so perhaps in that sense, functionally speaking, the problems are alignable. The solutions are alignable. And the third possibility that I talk about is maybe, notwithstanding all the technological change, you could say that as a structural matter, the problem has persisted in a meaningful sense, and the framers, because they were veterans, they had fought a war, thought about them, and because they had a more emergent perspective, they actually thought about and came up with better solutions than the leader of a militarily powerful country would. And so that's sort of what I end with.